Hello and welcome everyone. My name is Yasir Gulfraz and I'm your tutor for today's session. Uh, Today we will discuss our next session of aspect of tort law series. This is learning outcome 2, which is understand the law governing duty of care. So can you see my screen? Can you hear my voice? Okay, so let's get started. Indicative content, uh, casual link, new interesting intervening acts effective of negligence, medical treatment in the China of causation, the skull rules, duty of care test, establishing recognizing duty situation, neighbor test, Dongu versus Stevenson, three stages test, and case law of Capro versus Dickman, London Electricity Board 1961 and Compensation Act 2006, Public Policy and Local Authorities, Psychiatric Home Burnhill versus Young, nature and quality of harm suffered, primary and secondary victims, standards, basic responsibilities, main test. Key terminology, breach of duty. This occurs when an individuals or organizations fail to meet the expected standard of care, leading to injury, damage, or financial loss to another party. Reasonable standard of care, level of care, or reasonable purpose or professional would provide under similar circumstances to prevent harm or risk. Vicarious liability, legal responsibility of employees for actions of their employees if harm occurs within the scope of their job duties. Foreseeability, a reasonable person should be able to predict or anticipate potential risk or harm resulting from their actions or negligence. Any questions before I go further? Okay, so here a link for a video. I'll encourage you to watch this video. It is beneficial for you to enhance your knowledge about duty of care. Definition of duty of care. The duty of care is a legal obligations that requires individuals and organization is to act responsibly and avoid actions or inactions that would foreseeably cause harm others. Key elements existing of a duty of care or breach of that duty. So the breach cause harm or loss to the claimant. Development of duty of care, historical development. The duty of care has been developed through case law with key legal decisions shaping in its principle over time. So we also discussed yesterday Donhu versus Stevenson 1932. This case established the neighbor principle, which means that people must take reasonable care of avoid harming those who are closely and directly affected by other actions. Modern test for duty of care, the case of Capro Industries versus Dickman 1990. We also discussed this yesterday as well. Introduce a three-part test to determine whether a duty of care exists. Foreseeability. Was it reasonably foreseeable that the defendant actions would cause harm? Proximity. Was there a close relationship between the parties, or fairness, justice, and reasonableness? Is it fair to impose a duty of care and in the given circumstances? Statutory duty of care. Certain situations impose specific duty of care in addition to those established under common law. Occupiers Liability Act 1957 impose a duty of care on occupiers to ensure lawful visitors are reasonably safe on their premises. Shop owner, for example, shop owner must ensure walkways are free for hazards like wet floor. Occupiers Liability Act 1984 extends limited duty of care to trespasser if their presence is foreseeable, warning trespassers about dangerous machinery on the property. Health and Safety at Work Act 1974 requires employers to ensure that safety and welfare of employees and others affected by their activities. For example, providing proper training and equipment to employees handling hazardous material. Uh, Road Traffic Act 1988 establishes duty for road users to act responsibly and avoid harm to others. Driver must not exceed speed limits or driver under the influence of alcohol. Application of duty of care. Duty of care applies in various situations, each with its specific legal principles. Professional negligence. Professional Professionals must meet the standard of competent professional in their field. Balam versus Fryan Hospital Management Committee 1957 example of professional negligence. This case introduced the Balam test for medical negligence, which assess whether a professional acted in line with accepted standards. Employers' liability must provide a safe working environment, proper training, and protective equipment. Latimer versus Ace Limited 1953 highlighted an employer's responsibility to take reasonable precautions against workplace hazards. Product liability: manufacturers must ensure that their products are safe for consumers. Dong versus Stevenson's 1932. This case established the principles that producers owe a duty of care to consumers. Public authorities, public bodies owe a duty of care in carrying out their duties, through they are not always liable for policy decisions. Example: Hill versus Chief Constable of West Yorkshire 1989 determined that the police do not owe a general duty of care to crime victims. Any question so far? Breach of duty occurs when the defendant fails to meet the standard of care required in the circumstances. Standard of care judged by what a reasonable person would do in a similar circumstances. Professionals are assessed based on what their peers would consider appropriate. Example is a Bolam test we discussed about uh, this case. Bolam versus Foreign Hospital Management Committee. Remedies of breach of duty. Primary remedy for a breach of duty of care is damages which aim to compensate the victim of their losses. Compensatory damage restores the victims to their pre-home positions. Examples covering medical expenses and lost wages. General damage: non-economic loss such as pain and suffering, compensation of emotional distress after an accident. Special damage: quantifiable financial losses directly resulting from the breach, repair cost of property damaged by negligence. Any question so far? Right. Conclusion here for this section. Uh, the law governing duty of care has evolved through a judicial ruling and statutory laws to address a wide range of scenarios. It plays an important role in ensuring accountability, protecting individuals from harm, and providing remedies when duties are uh, accept or details. Definition: duty of care refers to legal obligation to avoid harm through reasonable actions or omissions. Historical development evolved from Donghu versus Stevenson case. Uh, so and refined by the Capro test. Statutory duty imposed by laws like Occupies Liability Act 1957, 1984, and Health and Safety at Work Act 1974. Applications include professional negligence, employees liability, product liability, and public authorities. Breach: failing to meet the standards to care judged by the reasonable person to professional standard. Conclusion and remedy: causation and remoteness. Harm must be directly caused by the breach and reasonably foreseeable the wagon mount. Remedies: damage includes compensatory, general, and special damage to restore the victim's position. Any questions so far? Definition: the test governing duty of care in negligence. The duty of care in negligence is a legal responsibility that required individuals or organizations to act in a way that avoids causing harm to others. Over time, courts have developed specific tests to determine whether a duty of care exists in different situations. These tests helps assess the relationships between individuals and their legal responsibilities. Tests governing duty of care. I'll quickly go through one by one. Established recognized duty situation. Courts have identified certain relationship where a duty of care automatically present due to the nature of the relationship. Some key example including doctors and patients, employers and employee, manufacturer and consumer. Three-stage tests: Capro Industries versus Dickman 1990. Uh, the Capro case refined the concept of duty of care by introducing a three-steps test. Reasonable foreseeably: was it reasonably foreseeable that the defendant actions could cause harms? In Halle versus London Electricity Board 1965, a blind man fell into foreseeable that blind pedestrians could be affected by such negligence. Proximity: there must be a close relationship between the claimant and the defendant: physical, relational, or situational proximity. For example, doctor has a duty to their patients but not necessary to random stranger. Fairness, justice, and reasonableness: it must be fair, just, and reasonable to impose a duty of care. Example is in Hoyle and Chief Constable of West Yorkshire 1988. The court ruled that police do not owe a duty of care to individuals victim of crimes due to policy consideration. Comparison of duty of tests, criteria: neighbor principle, foreseeable of harm to neighbor directly affected by one actions, Donghu versus Stevenson case, manufacturer's duty to consumers. Three-stage test, reasonable, foreseeable, proximity, and fairness, Capro versus Dickman 1990, used in a novel duty of care situations, determine if a duty exists. Established duty: recognized relationship inherently involved with duty of care, doctor-patient relationship automatically applied without needing to prove all three CAPRO elements. Key cases applications. Donghu versus Stevenson established this case established the neighbor principles formatting the basis of modern negligence law. Then Capro versus Dickman 1990 introduced the three stages test for determining duty of care. Uh, Halle versus London Electricity established that duty of care includes foreseeable risks to vulnerable people. Then Hill versus Constable 1989 confirmed that public authorities may not always owe a duty of care. Conclusion for this section, the law surrounding the duty of care is negligence has evolved through significant court ruling. The neighbor principle set the foundation, while the Capro 3 set test provided a structured method for analyzing new cases. In situations with an already established duty, such as doctor patient relationships, providing the duty of care is straightforward. These legal tests ensures fairness, accountability and justice in negligence claims. Any questions so far? Right. Next topic, define the current law relating to duty of care in cases of psychiatric harm. Psychiatric harm, also known as nervous shock, refers to mental health conditions that arise from witnessing or experiencing a traumatic event caused by someone else's negligence. However, not all emotional distress qualifies as psychiatric harm. The law has developed over time to differentiate between different types of victim and establish strict conditions under which claim can be made. Key principle of psychiatric harm. Definition of psychiatric harm. Psychiatric harm must be more than everyday stress, sadness, or worry. It needs to be medically recognized mental health conditions such as post traumatic stress disorder or severe depression. Landmark cases here Borhill versus Young. A pregnant woman suffered a miscarriage after seeing the aftermath of a motorcycle accident. The court ruled that the harm was not foreseeable because she was not directly involved in the incident, meaning there was no duty of care owed to her. Alok and others versus Chief Constable of South Yorkshire Police, 1992. Relatives of the Hillsborough disaster victims claimed psychiatric harm despite not being present at the scene. So, this case set out strict rules for who could claim psychiatric harm as a secondary victim. Primary and secondary victims. These are primary victims. These are people who are directly involved in the traumatic event and faced physical risk. Secondary victims, these are individuals who witness a traumatic event but are not physically harmed. So, primary victims, if you look at Dolio versus White Sons 1991 case, a woman inside a pub suffered several mental distress when a drawn cord crashed into the building. Since she was an immediate danger, she was recognized as primary victim. Example of secondary victim, if you look at the case of Alok and South Yorkshire Police set out key requirements for secondary victims: proximity to the event, close relation with the primary victim, means of perceptions, and recognized psychiatric illness. Nature and quality of home suffer. Conditions like PTSD or post uh, uh, traumatic disorder. clinical depression or an anxiety disorder, temporary disasters, or sadness is not enough for a claim. Foreseeability of rent both for both primary and secondary victims, the harm must be reasonably foreseeable to the defendant. Example on Bornhill and Young 1942. In this case, the court ruled that a person indirectly witnessing an accident was not foreseeable as a victim. Severity of harm, psychiatric condition must be severe enough to impact the claimant daily life, work, or general well-being. Cases of psychiatric harm, Bourne versus Young. In this case, a medically uh, yes, the claimant must be within a foreseeable zone of danger to claim psychiatric harm. Dulio versus White Sons, primary victim can claim psychiatric harm if physical harm was foreseeable. Alok versus South Yorkshire established strict rules of secondary victims, including proximity and relationship. Any question so far? Okay, conclusion for this session. The law on psychiatric harm is designed to strike a balance between compensating genuine claimants and preventing excessive claims for emotional distress. Through key cases like Bourne-Hill versus Young, Alok versus South York Police, courts have developed clear distinctions between primary and secondary victims. These rules ensures that only those who suffer genuine and foreseeable psychiatric harm can make legal claims. So, key cases we already discussed. If you look at here, Bonville versus Young, uh, here, and 1942, foreseeable Alok versus South Yorkshire Police 1992, secondary victims criteria, and also must be severe and recognized as psychiatric condition, for example, post traumatic disorder, severe depression. Any questions so far? Okay, so next is describe the standard test for breach of duty. When determine whether a person has breached their duty of care in a negligence case, the law applies a standard test. This test helps assess whether the defendant has failed to meet the level of care expected in a given situation. A key way to measure this is through the reasonable person test. This is an objective standard that examines whether a typical reasonable person would have done under similar circumstances. Standard basic reasonable man test. The reasonable person test is important way to judge if the defendant actions were appropriate. It considered how a hypothetical reasonable individuals would act in the same situations. So objective natures, the test does not take into account the personal skills, knowledge, or intention of the defendant. Instead, it applies the same standard of case of care for everyone. Key cases Blith versus Birmingham Waterworks Company 1956. There was fact was a water company installed a fire hydrant which later malfunctioned due to extreme cold, causing damage to nearby property. Legal principle: the court rules that the company had acted reasonably as it could not have foreseen such as unusual weather event. So important quote is Baron Alderson defined negligence as the failure to do something that a reasonable person would do or doing something that a prudent person would not do. Any questions so far? Features of the tests. The defendant actions are judged based on what a reasonable person would have done in the same circumstances. For example, a reasonable driver would follow speed limits and drive carefully to avoid accident. Flexibility, uh, while the standard remains objectives, the level of care expected may vary depending on the situations. Foreseeability of a risk, the test consider whether the harm was foreseeable. A reasonable person would take precautions to prevent objective risk, but is not expected to anticipate highly unlikely danger. Applications, the reasonable man test, ordinary individual judged by the standard of a reasonable person, professionals held to the standard of a reasonably competent professional in the same time. Case example is Ballum versus Fryeron. Uh, Learn or unexperienced person expected to meet the same standard or experience individuals. For example, learner drivers in Nettleship versus Western, case 1971. Children judged by the standard of a reasonable child of the same age, Mullen versus Richard, 1998. Any question so far? Right. Uh, Limitations and expectations. Unforeseeable events, a person is not considered negligent if the harm was caused by something completely unexpected or unavoidable. Example, if a sudden earthquake causes an accident, the person involved may not be held responsible. Special standards, some professions have specified standard of uh, care. For example, doctors are judged by the expected competence of a trained medical professionals rather than the average person. Vulnerable victims, if the defendant knows that the victim is particularly vulnerable, for example, child or an elderly people, a person, they may be required to take extra precaution. Summary of table. Reasonable man test evaluate whether the defendant acted as a reasonable. This is a summary we just discussed. Objective nature test is objective, applying the same standard regardless of the defendant's personal characteristics. Key cases: Blyth versus Birmingham Waterworks Company, 1956, established the definition of negligence and the reasonable man test. Applications: ordinary individuals, professionals, learners, and children are judged by relevant standard. Foreseeability: a reasonable person should prevent foreseeable risks but is not expected to predict a rare or extraordinary event. Conclusion for this section: the reasonable person test is fundamental principle in negligence law. It provides a clear and fair way to assess whether someone has breached their duty of care. By using an objective standard, the test ensures that individuals are held accountable for preventable harm while also recognizing that not all risk can be anticipated. The standard established in Blyth versus Birmingham Water Company's 1856 continue to be a key factors in determining liability in negligence case today. Any sorry, any questions so far? Okay, so let's move forward to the next part. Explain the meaning of public policy in the context of duty of care in negligence. In negligence cases, court considered public policy to ensure that legal decisions align with broader societal interests. Public policy prevent the law from imposing a duty of care in a situation where it could lead to negative consequences such as excessive lawsuits or hindrance of public services. Definition of public policy in negligence. Public policy in negligence means that the law should not enforce a duty of care if it conflicts with social well-being or leads to unreasonable legal outcomes. It acts as a safeguards to balance individuals' rights with the overall needs of society. Rules of public policy in duty of care. So, public policy plays a significant role in determining whether a duty of care should be imposed. Courts assessed several factors when making these decisions. Preventing a flood of claims. If every potential claim is allowed, the legal system could be overwhelmed. Example Alok versus Chief Constable of South Yorkshire Police 1992. Public policy limited claims for psychiatric harm to avoid excessive litigation. Encouraging social responsibility. Courts encourage responsible behavior but do not want to discourage beneficial activities. Protecting public services. Public authorities like the police and medical professionals are sometimes shielded from liability so they can perform their duties effectively. For example, Hill versus Chief Constable of Yorkshire 1989, the police were not held liable for failing to prevent a crime because doing so could hinder law enforcement. Balancing competing interests, court weigh individuals' rights against social needs. Example, doctors owe a duty of individuals, uh, patients, but must also consider public health priorities. Key cases highlighting public policy. Hill versus Chief Constable. Police were not liable as imposing duty could hinder law enforcement. Next is Capro versus Dickman 1990, established a three-stage test including fairness and policy concerns. Alok versus South Yorkshire Police 1992, public policy restricted secondary victims, claims for psychiatric harm. Nettleship versus Western 1971, learners driver were held to the same standard as experienced drivers to ensure road safety. Public policy in the context of novel cases. When the court handle new or unusual cases, public policy plays important role in shaping their decisions. Liability or for public authorities. Courts are careful when holding public bodies liable as it might discourage them from making necessary decisions. Limiting liability, public policy ensures that defendants are not held responsible for limitless or highly indirect consequences of their actions. Any question so far? Any concerns, issues, or questions? Okay, conclusion for this section. Public policy ensures that the duty of care is negligence law does not lead to unreasonable outcomes. Uh, it helps balance individuals' justice with uh, social interests, preventing excessive claims and protecting essential public functions. Uh, Landmark cases like Hill versus Chief Constable and Dalok versus South York Police demonstrate how public policy considerations remain central to the law of negligence. Let's move to the next section. Explain the breaks in the chain of causation. In negligence claims, establishing causation is important. The claimant must prove a direct link between the defendant's breach of duty and the uh, harm suffered. However, sometimes a independent event occurs that disrupts the links, breaking the chain of causation and potentially absolving the defendant of liability. Key elements of causation. To prove causation, courts assess two main elements: factual causations, but for test, the court asks, but for the defendant actions, would the harm have occurred? Explain Burnett versus Chelsea versus Kensington Hospital 1969. The court ruled that a doctor negligence did not cause the claimant's death, because the outcome would have been the same regardless of medical care. Legal causation, remoteness of damage, the harm must be foreseeable, consequences of the defendant actions. Example, the wagon mound number 1, 1961. If harm is too remote, the defendant is not liable. Any question so far? Break in the chain of causation. A break in causation, also called uh, novus actus intervention, intervenes. New intervening acts occur when an independent event significantly disrupt the causal link between the defendant's act and the harm. So, type of intervening acts, acts of third parties, acts of third parties. If third parties unforeseen actions contribute significantly to the harm, the chain may be broken. Example is Knightley versus Jones, 1982. A police officer's mismanagement of an accident scene caused further injury, breaking the causal link. Acts of the claimant. If the claimant's unreasonable actions contribute to harm, the chain may be served. Example is McHugh and Holland and Hannon and Cubits. In the claimant acted recklessly, worsening his injury, and the court ruled that his this broke the chain. Natural events, act of courts, unforeseeable natural disaster may absolve the defendant of liability. Example, a student flood destroying property may not, a sudden flood destroying property may not hold a defendant uh, responsible if it was not predictable. Expectations, events that do not break the chain. Some events do not break the chain of causations, even if they intervene between the breach and the harm. Foreseeable intervening acts: if the event is natural, consequences of the defendant's negligence liability remains intact. Example, Smith versus Leach, Brain and Company, 1962. A workplace injury triggered a pre-existing cancerous condition, but the employer was still held liable because the harm was foreseeable. Uh, Rescuer's actions: if someone is injured while rescuing a victim due to the defendant's negligence, the chain remains intact. For example, Hines versus Harvard, 1935. A police officer injured while stopping a runaway horse. was able to claim compensation. Key cases we just discussed on break in the chain. Knightley versus Jones, acts of third party police officers negligence broke the chain of causation. McHugh versus Holland 1969, claimant unreasonable actions broke the chain of causation. Smith versus Leachbrain 1962, foreseeable harm even with the pre-existing condition does not break the chain. Hines versus Harwood 1935, rescue actions do not break the chain if responding to the defendant's negligence. The Wagon Mound number 1 1961, harm must be foreseeable to maintain the chain of causation. Any questions so far? Right. So conclusion for this section: breaks in the chain of causation ensures fairness in negligence claims by holding defendant liable only for harm directly resulting from their actions. Courts carefully assess whether an intervening act events it's foreseeable or sufficiently significant to disrupt the causal link. Through established case law, this principle helps maintain accountability and prevent unjust liability. Any questions so far? Okay, next section 2.6, explain the requirement of reasonable foreseeability introduction. The principle of reasonable foreseeability, a key concept in negligence law. The principle helps determine whether a defendant should be held responsible for harm caused by their actions. The main idea is that the harm must have been reasonably predictable at the time of the act. If the harm was too remote or unpredictable, the defendant may not be liable. Key aspect of reasonable foreseeability. Definitions. Reasonable foreseeability means that a person of average intelligence and causation should be able and caution should be able to anticipate that their action might cause harm in a given situation. Objective standard. The principle is objective, meaning the focus is not on what the specific defendant thought, but rather uh, what a reasonable person in the same situations would have foreseen. Relevance. This concept is essential in two areas of negligence law: duty of care. To establish that the defendant owe a duty of care, the harm must have been a reasonably foreseeable outcome of their actions. Remoteness of damage, the harm must be closely related to the defendant's actions and not too far removed to justify liability. Right. Applications in duty of care. Uh, Courts use reasonable foreseeability as part of the CAPRO test to determine whether a duty of care exists. Foreseeability of harm, the harm must be something that a reasonable person could predict. Again, example is Donoghue versus Stevenson 1932. A consumer become ill after drinking ginger beer that contained a snail. The court ruled that the manufacturer should have foreseen that a defective product could cause harm. Proximity and justice. Apart from foreseeability, courts also consider the relationship between the parties and whether it is fair to impose a duty. Application in remoteness of damage. For a claim to succeed, the harm must not only be foreseeable but also closely connected to the defendant's action. Here, example of the Wigan Mount case Law number 1, 1961, a ship leaked into a harbor while later caught fire and caused property damage. The court rules that this type of fire damage was not foreseeable as oil and water does not usually uh, ignite. Therefore, the defendant was not liable for the fire. Again, key cases in for this section. Donegal versus Stevenson 1932 established that harm caused by a defective product was reasonably foreseeable to the manufacturer. Halle versus London Electricity Board 1965, harm to a blind person was foreseeable when a trench was left uncovered. The Wagon Mound number 1, 1961 introduced the rule that foreseeable types of harm are compensable. Kent versus Griffiths 2000, foreseeability of harm when an ambulance fails to arrive promptly. Example of reasonable foreseeability. Driving, a reasonable driver should foresee that speeding could cause accident and harm pedestrian health care. A doctor must foresee that failing to sterilize medical equipment could lead to infection. Constructions, a contractor should foresee that not installing safety barriers could result in injuries as a work site. Limitations of reasonable foreseeability, unforeseeable events, definitions. Defendants are not liable for harm caused by rare or extraordinary incidents. Example, if unexpected extreme weather damage a building, the owners may not be liable for injuries caused. Specificity of harm, the exact way in which harms occurs does not have to be foreseeable. Only the general type of harm, example, Hague versus Lord Advocate 1963. A, in this case, a child was injured when paraffin lamps caused an explosion. So, although the explosion was unexpected, the risk of injury was foreseeable, so liability was established. Conclusion for this section, the principle of reasonable foreseeability ensures that the only predictable harms leads to legal responsibility. This approach balances fairness, protecting defendants from excessive claims, which ensuring that victims receive justice for harms that could have been anticipated. It plays a key role in establishing both duty of care and remoteness of damage in negligence law. Any questions so far? Let's move to next section 2.7, analysis, uh, con- causation and the legal tests that are needed. Uh, the principle of reasonable foreseeability ensures that only predictable harms leads to legal responsibility. This approach balance fairness, protecting defendants from excessive claims while ensuring that the victim receive justice for harm. Could sorry, again I'm repeating conclusion. Uh, because here are some definition. Harm must be reasonably prediction by a person of ordinary prudence in the same of circumstances. Standard objective based on what a reasonable person would foresee. Duty of care. Harm must be reasonably foreseeable to establish a duty of care. For example, Donoghue versus Stevenson case. Remoteness of damage harm must not be too remote, only foreseeable type of harm, or compensable wagon mount case. Key cases: Dongu versus Stevenson, Halle versus London Electricity Board. The wagon mount number one, defendants are not liable for rare, extraordinary, or highly specific events. Any questions so far? Right, so let's move to the next section, which analyzing causation and the legal tests that are needed. In negligence cases, proving causation is essential to establish liability. The claimant must show that the defendant's action directly caused the harm suffered. To ensure fairness, courts apply specific legal tests to determine whether causation exists. Causation is divided into two key parts: factual and legal. So, factual, this confirms whether the defendant's action directly led to the harm, and then legal, this ensures that the harm is not too remote and is sufficiently connected to the defendant's actions. Factual causation, but for test and multiple causes. But for test is simple way to determine factual causation. It asks, would the harm have occurred but for the defendant's action? If the answer is no, the defendant is responsible. Case example is Barnett versus Chelsea Kensington Hospital 1969. The effect was a man was poisoned with arsenic and went to the hospital, but the doctor sent him home without treatment. He later died. However, medical evidence showed that he would have died even with proper treatment. Outcomes: the hospital was not held liable because the death would have occurred regardless of their actions. Multiple causes, sometimes more than one factor, contributes to the harm. In such cases, the court looks at whether the defendant's action materially contributed to the damage. Case is Bonington Castings Limited versus Wardlaw 1956. A factory worker developed a lung disease due to prolonged exposure to dust. Some of the dust exposure was due to employer's negligence. So the outcome was court found that employees liable because their negligence materially contributed to the worker's illness. Any questions so far? Right. Legal causations. Even if factual causation is established, the law ensures that the defendant is only responsible for harm there is reasonably foreseeable. Two important legal principles help determine this. A remoteness of damage. The law does not hold defendant responsible for harm that is too distant or indirect. The harm must be foreseeable consequences of their actions. Case example: the wagon mount 1961, number one. The facts was oil leaked into a harbor and later caught fire, causing extensive property damage. The fire was unexpected. Outcomes: the court ruled that the fire was too remote because a reasonable person would not have foreseen that oil on water would ignite. Principles are defendants are only responsible for harm that is reasonably foreseeable. Novus actus intervenes, intervening acts, uh, and independent act or event can break the chain of causation, meaning the defendant is not longer liable. This can include acts of third party. If an independent third party in party's action is unforeseeable, it can break the chain of causation. Cases Knightley versus Jones, 1982. A police officer mistake once an accident. The original driver was not held liable for the new harm caused. Acts of the claimant: if the claimant owns unreasonable actions contribute significantly to their harm, they may break the chain of causations. Case example: Matthews versus Holland, 1969. A worker who jumped down stairs after injuring his legs was found responsible for worsening his injury. Natural events: unpredictable natural disasters or extreme weather can also break the chain of causation if there are entirely unforeseen. Test used in causation to ensure fair judgments. Courts apply different tests. Okay, so for example, but for test asks whether the harm would have happened without the defendant's actions. Key case is a Barrett versus Chelsea and Kensington Hospital, 1969. Material contribution test determines whether the defendant actions significantly contributed to the harm. So Bonington uh, casting were limited versus Ward laws, 1956. That's it for today. Any questions, any concerns, any issues so far? Any questions? So here are some case laws. You can also visit your management system for further reading to get further laws, case laws, and also some law of tort books. So thank you very much for joining me. Thank you very much joining me for this evening. I'll see you tomorrow at 11 o'clock for our next session. So, by if you have any questions, concerns, or issues, you can drop me an email at yasir@ukversity.co.uk. Thank you very much, everyone. Bye and good night for now.